If you're a social media agency and you're using influencers to help promote your client, the brand's products and services, pay attention to the next 6 tips I share in today's video. My name is Mitch Jackson. I've been helping business clients for the last 32 years avoid litigation and trial using tips just like this. And I think you'll find these tips useful, especially if you're an agency right in the middle of the brand and the influencer. Tip number 1, use written agreements with the brand and with the influencer. In your written agreements, specify all of the terms and conditions of the influencer marketing and branding project on behalf of your client, the brand. I'm talking about which platforms the influencer will be expected to influence on, the frequency and the duration of the influencing campaign, and when it comes to numbers, what will the influencer be paid and how will he or she be paid by your agency or directly by the brand because of your participation as a social media agency in this project. Tip number 2, with your client, the brand, make sure you specify in writing exactly what is allowed and not allowed in the influencer marketing campaign. It's critically important that you have a meeting of the minds with the brand before reaching out and securing an influencer to share their products and services. Frankly, this is a big area where I see many social media agencies drop the ball because what the brand's expecting and what the influencer ends up doing or believes that he or she is expected to do are not the same thing. So have a meeting of the minds and put everything in writing. Tip number 3, with your influencer, enter into an agreement. And in that agreement, make sure that the influencer agrees to follow all state and federal rules, regulations, and laws. This includes all FTC disclosure and compliance obligations, and you make sure that it's in writing so there's no misunderstandings. Tip number 4, with your influencer, put into writing exactly what he or she can and cannot do. I understand that you want the influencer to tap into his or her personality, his or her brand, okay, that actually allowed them to become an influencer in the first place, to help your brand, your client market the products and services. But you do want to have limits. You do want to have boundaries. You want to make sure that the influencer is on the same page as you and your client, the brand, with respect to what he or she can and cannot do. So specify that in writing. Tip number 5, make sure the influencer agrees to have liability insurance coverage. If he or she negligently or intentionally does something wrong, they violate state or federal law, maybe they don't disclose like they're supposed to, and because of that, there's a third-party claim. Make sure that he or she is protected with liability insurance and your agency and your brand are included under riders, which is an additional document. It's additional coverage under the influencer's policy that protects everybody. Now, if the influencer doesn't have liability insurance or for whatever reason is unable to secure liability insurance, see whether or not if you as the agency can add the influencer and your brand as a rider under your existing liability insurance policy, or reach out to your insurance company and see if you can secure a second policy that covers everyone involved in this particular marketing and branding campaign in case the influencer does something wrong. Tip number 6, make sure in your agreement with the influencer that there's a hold harmless and indemnity provision in the agreement. That's something that protects you separate and apart from liability insurance. All that is that if the influencer's done something wrong, and hopefully this will never happen, but if he or she does something wrong, they agree to come back and hold you harmless and hold your client, the brand, harmless. They agree to reimburse you for your attorney's fees. They agree to reimburse you for any damages that you've been exposed to by unnecessarily being included in a claim or a lawsuit. An indemnity, hold harmless, and waiver provision in your contract with the influencer, a valuable asset that I would like to see every social media agency start incorporating into their social media agency influencer agreements. My name is Mitch Jackson. If you found these 6 tips useful, connect with me on social media at Mitch Jackson. Get my new book, The Ultimate Guide to Social Media for business owners, professionals, and entrepreneurs, and stop by streaming.lawyer and say hi. Take care and make each day a masterpiece.